Hey guys, welcome back to Ethereum Update. I'm Bob Chow. It's great to see you guys again. Today I'm going to discuss the ongoing litigation between R3 and Ripple. And before I go into this, I just want to mention that I am a big fan of Ripple. I'm not trying to spread FUD. I myself will plan on holding Ripple for a long time. And basically I'm just discussing what's going on, and I'm just going to share my viewpoint of what's going on. I'm not trying to scare anybody. I'm not trying to, speak ill of Ripple, okay, guys? I know that some of you guys are very sensitive about defending Ripple, okay? So I'm just going to share my viewpoint. This is not investment advice. This is not legal advice. This is just my own opinion, okay, guys? So basically, as you guys might know, R3 and Ripple entered into an agreement where R3 would have the option of buying 5 billion XRP at a pretty low price, okay? And basically, the value of this option is like $1 billion plus, okay? So it's worth a lot of money, okay? Now, before R3 could cash in on this option and get the $1 billion, Ripple canceled the option and said, no, you guys can't exercise this option because you did not come through on your end of the bargain. You did not fulfill your obligations according to the agreement, and therefore we are canceling the option. You do not have $1 billion, okay? Now, basically, what did Ripple say that R3 reneged upon? What is Ripple's complaint against R3? Ripple is complaining that R3 kind of misrepresented itself, okay? So I'm just going to read part of the complaint that Ripple is setting forth in California. So Ripple is complaining that R3 touted itself to Ripple as a leading consortium of banks with whom Ripple should partner. Okay, so what that means is R3 says, we're a big consortium. We're associated with a ton of banks, and you better partner with us, okay? R3 represented to Ripple, among other things, that R3 would work to get Ripple access to R3's large body of banks, would help promote Ripple's technology and XRP to those banks, and would be a foundational component of Ripple's success. Okay, so what that means is R3 says, we're going to work to make sure that you have access to the banks that we know. We're going to help promote Ripple's technology. We're going to help promote XRP. And we're going to really help you and be a foundational aspect of your success. Okay. And with respect to these efforts, R3's CEO assured to Ripple that the end game is commercialization of a product. Excuse me. So basically, this is what Ripple is saying that R3 promised, okay? And based upon these representations, based upon these promises, Ripple entered into a technology provider agreement, an option agreement, which gave R3 the option to buy the $5 billion, or the 5 billion XRP, which is now worth $1 billion, okay? So, let's take a look at Ripple's arguments. I think that in order for Ripple to cancel this contract, okay, it's got to prove that a breach occurred. And what is a breach? A breach basically means that you agreed to certain terms of the agreement and you decided to not honor your terms that you agreed to. So basically, Ripple has to prove that R3 made these promises and basically is in breach of these promises. But based upon my understanding, these representations are very, very vague and very open-ended. Specifically, R3 represented to Ripple that R3 would work to get Ripple access to R3's large body of banks. Okay, I understand what that means, that R3 said that we're going to help you get access to the banks that we know. But what is the time frame where this is supposed to occur? How is this supposed to occur? There is a lack of specifics regarding what access means, when it's supposed to occur, and because of the lack of these specifics, I think that Ripple is going to have a hard time showing that R3 breached its terms in saying that we promise to give you access to banks. I think that R3 can argue that, you know, right now we're busy right now, but we intended to provide you access in the future, because in R3's representations to Ripple, there's no time frame. Okay. Similarly, R3 represented to Ripple that R3 would help promote Ripple's technology and XRP to banks, and it would be a foundational component of Ripple's success. Okay, but this is also very open-ended and very broad. I mean, what does that really mean? A foundational component of your success. There's no metrics by which to judge whether or not this condition's been met. Okay? You know, I would have been much more sympathetic to Ripple if Ripple had put in some terms like, we need to be involved in at least 3 presentations before your 3 largest banks by this particular date. Or something like, we need to have this many transactions occur with this particular bank by this date. See, by setting specifics like that, then and only then can you really prove that a breach occurred. So I really think that, you know, R3 I think has a pretty strong case against Ripple, because I think Ripple will have a hard time proving that a breach occurred in the material terms of the contract, and therefore Ripple does not appear to have grounds to cancel that option. So, you know, based upon my understanding, I think that R3 appears to have the upper hand in this litigation. Now, a lot of you guys might say, well, what about in Delaware? The Delaware court appeared to hand Ripple a victory. But actually, based upon my understanding, the Delaware court said that they did not have jurisdiction over the case, which is a little bit different than judging the case on its merits. Specifically, what that means is to decline jurisdiction means that the court basically said, we are not the right court to go to, so go to a different court. Go to New York, go to California. Don't come to us for this particular case. The Delaware court didn't really look at R3's claims, didn't look at Ripple's claims, and did not really judge the case on the merits. So, you know what? I really think that in this case, R3 seems to have the upper hand. And you know what I think happened? I think that Ripple originally probably provided R3 this option because I'm not sure that Ripple really foresaw that there would be a 30x increase in Ripple's price. So I don't think that Ripple really realized that this option would be so valuable as to be worth more than $1 billion. If Ripple had known that this option was more than $1 billion, I think Ripple would have been more forceful in its terms and would not have been so vague in just accepting that R3 would help, would promote. I think that Ripple would have been more insistent upon clear terms, like we want this bank to agree using XRP. We want this much XRP to be exchanged. We want it to be done by this date. Okay? But it just seems as though, unfortunately, Ripple's partnerships, and this is kind of an overall problem that Ripple I think is dealing with. Its partnerships are very vague. Like it doesn't seem as though there are specific benchmarks that each partner has to meet by certain dates, and therefore a lot of these partnerships are going to be, I think, troublesome for Ripple because a lot of these partners, they're not really totally aligned with Ripple. For instance, R3 could be even considered as a competitor of Ripple. Okay, so yeah, when you've got partners that aren't totally aligned with your interest and aren't enthusiastic about moving forward with the partnership, unless you've got specific terms that you can hold this partner to, it's gonna be trouble. Okay, so those are my thoughts on the litigation between Ripple and R3, and those are kind of some other comments I had. I also shared some comments about Ripple's partnerships in general. Like, what are these partnerships? What can be really enforced in these partnerships? I think that that's going to be a problematic issue that Ripple has to deal with going forward. I'm going to make another video actually about this litigation, and it's going to be a little bit more in depth with respect to some of the legal issues, specifically the evidentiary issues. And in this other video, I'm going to explain why Ripple appears to be filing in California and R3 appears to be filing in like New York. Why are each of these parties choosing different venues to file their cases? I'm going to go into that a little bit in the next video, but that video might be a little bit boring for some of you guys who aren't really interested in legal matters. Okay, well, in any case, I hope this video has been helpful for you guys. As I said, I'm not trying to spread FUD about Ripple. I love Ripple. I love Ripple, guys. I love XRP, okay? I'm a big XRP fan. But in this particular case, wow, it just seems as though R3 does seem to have the upper hand in this litigation. So I'm going to keep track of this, and please feel free to leave comments. If you thought this video was helpful for you guys, please feel free to leave a comment. I read all the comments, and I will try to respond to all of them. And please feel free to subscribe to this video as well. Thank you so much, guys. Bye.